There are other constitutional challenges that can be made. Any restriction on speech has, there are numerous ways in which the First Amendment can be violated by a government regulation. And I'm just going to kind of run through these. We have a section on each of these in the First Amendment booklet. My purpose here today is I want to at least have you be aware of what some of the issues are, so that when you are subjected to one of these situations, hopefully you'll be able to recognize it as, wait a minute, this seems like this may violate my rights, this might not be a valid restriction, and and then give us a call, or we can deal with it and try to help out. But one of the constitutional challenges for a restriction on speech is where the government has placed a prior restraint on speech. When the government determines whether or not speech will be allowed in a public place, or otherwise imposes burdens or restrictions upon speech, before that speech can be expressed publicly, that's a prior restraint. Sometimes a prior restraint is upheld by the court, and sometimes it's held to have been violated the Constitution. But that's something that you need to recognize. If you're being restricted before you even get a chance to get your message out, before you even get to go into the park, before you even get to open your mouth, before when there's a restriction before the speech even occurs, in many circumstances that violates the Constitution. A related concept is what's called unbridled discretion, and that's where you have a decision maker, whether it's somebody deciding whether or not to issue a permit, or whether it's somebody that a police officer comes and deals with a situation following a citizen complaint. In that situation, if there's too much discretion allowed to the decision maker, whether it's a police officer or a public official of some kind, determining what speech is allowed and what speech is prohibited. If there's not sufficient guidelines and it's just left up to, apparently left up to the whim or the judgment of, whoever's on the scene making that decision, that usually is going to be held unconstitutional, because we don't allow government officials to just decide on the spot what speech is allowed and what isn't, because it's too easy for that to be abused. It's too easy for that to end up being a form of censorship. So that's another concept where we sometimes have challenges to an ordinance or a law. Vagueness is another one. If the prohibitions of the law or the ordinance are not clearly defined, then the statute or the ordinance may be too vague and may be unconstitutional because of that. Also, if it's overbroad, if the statute or the ordinance is if it not only will restrict or affect speech that's not protected or speech that's causing a problem, but it also affects a lot of other speech, or even potentially affects a lot of other speech, then that restriction is going to be held to be unconstitutional. We had a situation where somebody was cited for violating a noise ordinance that said it was illegal to make loud, disturbing, and unnecessary noise. And so we challenged that in court, and the city ended up dropping the case before we had a chance to get a judge make a ruling on that. They just gave it up and said, we're going to drop the citation. So, and what part of what my argument was is that that was an overbroad restriction on speech, that standard just made it, where it applied to too much. Equal protection is another way of challenging a restriction or an ordinance. Sometimes you'll have a law or an ordinance that will make distinctions between one group of people versus another group of people. And the law requires that people who are similarly situated need to be treated alike. And if the law does not treat people alike, then there may be an equal protection violation. Sometimes we see equal protection arguments come up in the context of what's called selective enforcement. And that's where we had downtown DeLand, the guy in the music shop put his big amplifiers out and he was blasting loud music, and we had preachers out there with megaphones. And so the preachers started preaching with megaphones because we couldn't be heard because of the amplification of the music. And somebody complained to the police about the preaching. And so the police came and they tried to tell us with this music blasting that we had to stop using the megaphones. And I was trying to reason with the officers that those amplifiers are louder than our megaphones. And so if the problem is we're making too much noise, then you can make the amplifier stop and make us stop, and that's fine. But if you're going to enforce a noise ordinance against our megaphones, and you're not going to enforce that same ordinance against these amplifiers that are even louder than we are, that's selective enforcement, and that violates the equal protection. So sometimes we have situations like that come up, or that at least an argument could be made that this was selective enforcement, and that violates the Equal Protection Clause of the Constitution. There's another interesting thing that I came across in my research called an unconstitutional condition, and that's where the government conditions the receipt of a benefit or a privilege on the relinquishment of a constitutional right. And we go on, into this in our booklet. There was a case where there was an annual protest up in Georgia, and the protesters were required to go through a metal detector in order to enter the park where the protest was going to be. And that is a violation of their Fourth Amendment right against unreasonable search and seizures. And so the idea was, if you want to go into this park and express and exercise your First Amendment right to protest, you have to waive your Fourth Amendment right to unreasonable searches and seizures, because we're not letting you go into the park for First Amendment purposes until you go through our metal detector. And so there was a lawsuit about that, and the court held that that was an unconstitutional condition. You cannot tell somebody that they have to waive one constitutional right in order to exercise another constitutional right. And so it doesn't come up that much, but I found that to be really interesting. So we've got that discussed in our booklet.